Interestingly, the respondent's lawyer is also a woman, and the petitioner's lawyer is also a man. So it was more like men supporting men and women supporting women. Court of Appeal, hear me out. I think the High Court was wrong. The parties did not agree with the Court of Appeal. Both of them disagree with the Court of Appeal. The woman said, no, I disagree. And the woman went to the Supreme Court. Guess what? The Supreme Court, made up of 5 judges, 3 males and 2 females, they took a decision that was divided. The 3 men agreed with the man, and the 2 men agreed with the woman. In this video, we discuss the facts, the issues, and the court's decision in the case of Peter Adjei versus Margaret Adjei. I'm Godwin Selassie Takbo, and this is Make It Legal.
Make it legal.
So, on the 21st of April 2021, the Supreme Court of Ghana rendered its decision in a case that traveled all the way from the High Court through the Court of Appeal to the Supreme Court. And the Supreme Court decision on this matter holds a lot of principles that are important to marriages in Ghana, especially when they are dissolved. Particularly also, it also clarifies a lot of legal principles that are applicable to settlement of property right of parties after a marriage is dissolved in accordance with the law. So we'll delve into that, but first let's appreciate the facts of this case. Now, what are the facts? So the facts are pretty simple. Peter Adjei, simply we'll call Peter or the petitioner, has been married to Margaret Adjei for 12 years, and they have 2 children. One is 11 years and one is 8 years. Now, these parties had issues with the marriage, and the petitioner decided to go to court and dissolve the marriage. The marriage in question was a customary law marriage, so they still opted to go to court to have it dissolved by the court. So they petitioned the court for the court to dissolve the marriage. And in the High Court, the petitioner, who is Peter Adjei, requested the court to, number 1, dissolve the marriage between them, and also to grant custody of the children to him. And the woman, on the other hand, who we call the respondent, that is Margaret in this case, decided to also ask that, you know what, I need 5 things to be given to me when this marriage is dissolved. What are these 5 things? The first one is that give me the matrimonial home, which is one of 4 flats or units of flats constructed by the petitioner on his self-acquired plot of land at Cantonment, Accra. So he said, give me that matrimonial home and let me keep it as mine forever. Then Margaret also says that the court should order the petitioner to pay her 400,000 Ghana cedis as financial provision or a compensation after the marriage is dissolved. And then she also said that the court should order the petitioner, Peter in this case, to pay her 2,000 Ghana cedis every month as a maintenance fee for herself and the 2 children who she wants custody of. And then second to last relief that she was claiming was that the court should also order the petitioner to give her 2 stores of the many stores the petitioner has along the Spintex Road. So she wants 2 of these stores given to her as hers forever. And last but not the least, also, she also wants the court to order the petitioner to pay for the cost of her litigation in court. So these are some of the things that she was expecting the court to grant her. Now, at the High Court, again, the court heard the parties, went through trial, and took all their evidence in support of their cases and came to a conclusion that marriage between the parties can be dissolved and was dissolved by the court. And the court also stated that even though the petitioner wanted custody of the kids, the court did not find a good basis to grant custody to the man. So the court granted custody of the 2 children to the respondent. The third relief the court granted was that the woman was entitled to 1 of the 4 flats that the man has built on his own self-acquired property at Cantonment. The court said that 1 of those flats should be given to the woman as hers forever. And the court also granted the woman 500,000 Ghana cedis as compensation of financial provision following the dissolution of the marriage. And that amount of money was indeed more than the 400,000 the woman actually asked the court for. But the court explains that it is for her to be able to complete the 1 flat they've given her, because that 1 flat which is being used as a matrimonial property was not entirely completed. So the woman was used 100,000 of the 500,000 to complete that 1 flat at Cantonment and then be there with their 2 children as hers forever. And the court also granted 1,500 cedis to her as maintenance. So the man was to pay 1,500 cedis to the woman as a monthly maintenance fee for the children and the woman herself. So this was a decision of the High Court. And guess what? The petitioner disagreed with the court. And when you disagree with a court decision or court's judgment, you don't go to the street and fight. If you disagree with the court's decision, you have the right to appeal against it. So that is what the petitioner did. He rightly lodged an appeal against the decision of the High Court. That Court of Appeal, hear me out. I think the High Court was wrong in its judgment or in its conclusions on the case we brought before it. Therefore, rehear the whole case of the High Court and come to a different conclusion. So he was saying that the High Court was wrong in reaching a conclusion that the woman was entitled to one of the flats. One of the grounds of appeal at the Court of Appeal was that the Court of Appeal should review or rehear the decision made by the High Court and come to a conclusion that the High Court was wrong in holding that the woman was entitled to one of the flats at Cantonment, because the High Court failed to consider that the fact that he himself personally acquired the land on which the house is built and personally took a loan from a bank to build the house. So therefore, the house was not acquired jointly by the parties to be shared. Therefore, he asked the court to overturn the decision reached by the High Court. Then the petitioner also at the Court of Appeal stated that no, the High Court did not consider the means of the parties before ordering the petitioner to pay 500,000 Ghana cedis to the respondent. He says, you didn't look at the work we do, how we earn income, how much we earn. You did not look at the means of earnings of the parties before going ahead to order that the petitioner should pay 500,000 Ghana cedis to the respondent. Therefore, that decision is wrong and it should be reversed. Then again, he made a similar argument also that the High Court did not consider the means of the parties when he ordered the petitioner to pay a monthly amount of 1,500 cedis to the respondent as maintenance fee. So these three issues were his disagreement with the decision of the High Court, and the Court of Appeal was to hear him on this disagreement. The woman did not disagree with the decision of the High Court, so she did not appeal against it. It was only the man who appealed against the decision. What is the Court of Appeal decision on the case that was brought by the man that it should review or reverse the decision of the High Court? The Court of Appeal said that the order of the High Court granting the woman the right to have one of the flats for herself as a matrimonial home was wrong, because it was not supported by the facts and the evidence that were adduced by the parties. Now, some of the reasoning that influenced the Court of Appeal's decision to overturn the High Court decision for the woman to keep the one flat are reflected in the judgment of the Court of Appeal. I think for clarity, I'll read some things that influenced the decision of the Court of Appeal to reverse this particular decision of the High Court for you. Let me read from some of the relevant portions of the judgment. The first one is that the Court of Appeal stated that the High Court judge relied on the case of Mensah versus Mensah, a 2012 decision, and held that once the property was acquired during the subsistence of the marriage, the respondent, by operation of law, had an interest in it. The case of Mensah versus Mensah Supra, that is above, is a case where both parties at the beginning of the marriage did not have money. The husband was a staff at the ministries in Accra, while the wife was a petty trader. From the fact of that case, it will have seemed against equity and good conscience for the husband alone to have taken over the properties they acquired during the marriage, as the contribution of the wife to the acquisition of the property was immeasurable, even though she could not quantify it in monetary terms. We are thus of the opinion that Mensah and Mensah Supra did not lay down a general principle of law that any property acquired during the marriage, including through inheritance and loans, ought to be shared between the parties, especially in cases like these where the loan has not been repaid. The court went on to say that in the case of Kwatson and Kwatson, a 2012 decision also, the Supreme Court, while affirming the position in Mensah versus Mensah, held that in partitioning properties acquired during marriage, the court must consider the equities of the particular case. The Supreme Court in the case of Atta and Atta, also affirmed the ratio, that is the reasoning, the legal reasoning in Mensah versus Mensah, and further held that properties acquired during the subsistence of the marriage is presumed to be jointly acquired property. However, the presumption is rebutted under certain instances, particularly where the other spouse acquired the property by gift or through succession. In the same vein, where a party takes a loan to develop his self-acquired plot during the subsistence of the marriage, the property shall not be considered a family property until the loan is repaid. The court went on to say that in the case of Finn versus Finn, also a 2014 decision, the Supreme Court distinguished the right of an individual to acquire a property from its decisions rendered in Mensah versus Mensah and Kwasin. The Supreme Court held that there are situations where within the union, parties may acquire property in their individual capacities, and that position is envisaged by Article 18 of the 1992 Constitution. So what the Court of Appeal was simply saying is that there are instances where even though you are living together as couples, you can own your own property as a husband or as a wife. You can have a house or a car, a phone, anything material or physical or intangible, and it will be yours without the other person having a share in it. But again, the Court of Appeal was saying that there is a presumption of law. It is always presumed that once you acquire the property, at the time the marriage is still subsisting, it is presumed that that property is jointly acquired. I believe you're enjoying this video so far. You want to do us a favor as you watch and enjoy our videos. You want to like the video, just now do click on the like button to like it, and when you are done also please subscribe to the channel and drop a comment as well as know what you think. Do you agree with the Court of Appeal, the High Court, or the Supreme Court? What are your reasons for disagreeing with the Supreme Court or for agreeing with the Court of Appeal or the High Court? Let's know what you think in the comment section. Please don't forget also to share this video to a friend. It is just a presumption that once you acquired it during the time the marriage is subsisting, it is presumed to be jointly acquired. But that presumption can be rebutted. In other words, an evidence can be produced to show that it is not a joint property and should not be shared equitably between the parties. And it is the reasoning that has already been established in previous cases that I mentioned. You heard the case of Mensah and Mensah, which is a 2012 decision that laid the foundation of how properties acquired between parties should be distributed equitably. So with this reasoning, the Court of Appeal concluded that the decision of the High Court granted the woman one of the flats without regard to the fact that it was acquired solely by the man with a loan, or it was built, even though during the substance of the marriage, it was built by a loan procured by the man. And this loan was still not paid in full. In other words, he has not yet acquired the house because it's still subject to loan. So that decision of the High Court was to be set aside as wrongful. Then the Court of Appeal also said that the amount of 500,000 Ghana cedis that was awarded to the woman, as in to be paid by the petitioner to the woman as financial provision, was very fair and accurate. So the court said that that decision of the High Court should still stand. The court also, in the same vein, also agreed with the High Court that the 1,500 cedis for maintenance fee for the respondent, that is the woman and the kids, was very sufficient and should still stand. So those two decisions are still upheld by the Court of Appeal. But would the parties agree with the decision of the Court of Appeal? Or do you agree with the decision of the Court of Appeal? Or if you were the Court of Appeal judges, you would have actually reversed all the decisions made by the High Court or set them aside? Or you will certainly have just accepted all of them without varying any of the terms? Let me know what you think in the comment section. Now, as you probably might have also envisaged, the parties did not agree with the Court of Appeal. Both of them disagree with the Court of Appeal. The petitioner says that, I disagree with the Court of Appeal when he says that I should still pay the 500,000 Ghana cedis to the woman and also pay 1,500 cedis to the woman as monthly maintenance fee. I disagree entirely with the Court of Appeal. The woman, on the other hand, says that I disagree with the Court of Appeal when he says that I am not entitled to the property at cantonment because the land was acquired by the man before the marriage even started, and it was only during the substance of the marriage that he procured loan to build the house on it. So the woman said, no, I disagree. And the woman went to the Supreme Court. Guess what? The Supreme Court, made up of 5 judges, 3 males and 2 females, they took a decision that was divided. In other words, all the 5 did not go on one side, either the side of the man or the side of the woman. But here is an interesting thing. The 3 men in that case at the Supreme Court agreed with the man, and the 2 men agreed with the woman. I don't know what you think. It might not probably seem like men supporting men or women supporting women, but it is their position of the law. It is how they interpreted the law and how they applied it that appears to be that the men, of course, might have been coming from a man's standpoint before interpreting the law and applying it, and the woman also must be coming from a woman's standpoint before interpreting the law and applying it. So sometimes the standpoint we come from, the environment we come from, the people we are, influence how we interpret things and how we apply it. So it just so happened that in this case, all the 3 men on the panel were in majority, because the Supreme Court is often constituted for its cases by 5 judges, and when they have 5, when 3 of them agrees on something together, that becomes a decision of the Supreme Court. And when 2 also disagree with the 3, those 2 become people who have dissenting opinion, and they are also allowed to write their judgment. Now, in this particular case, it's 4 of the 5 judges wrote something. One of them, who is a male also, just agreed with the other 2 men and said, what you have already written all out, I've written, and I agree with you that so and so should be the outcome of the case. So it's interesting how the men agree with the petitioner, who is the man, and the women agreed with the respondent, who is a female. It is the woman who appealed against the decision of the Supreme Court first, and the man, on noticing that the woman has appealed against the decision, also filed what we call a cross appeal to be heard on certain grounds. So both of them, in a sense, disagree with the Court of Appeal and filed their appeal at the Supreme Court for hearing. So on what grounds was the petitioner before the Supreme Court? And what grounds was the respondent also before the Supreme Court? The petitioner simply says that the 500,000 you have ordered me to pay and the 1,005 are not supported by the means of the parties. Therefore, it cannot stand. It must not stand. That is all that the petitioner says before the Supreme Court. Supreme Court, ensure that you order me not to pay the 500,000. But the woman, on the other hand, also went to Supreme Court and said that, you know what? I want you to order the man to transfer the house to me because the Court of Appeal was wrong in overturning the High Court decision. In other words, maintain the High Court decision and set aside that of the Court of Appeal. So those were the 2 key grounds on which they have appealed against the decision of the Court of Appeal. So there were basically 2 issues that the Supreme Court has resolved. And these 2 issues are, number 1, did the Court of Appeal err when it reversed the order of the trial High Court in respect of the matrimonial house or the settlement of one of the 4 unit flats at cantonment on the respondent as contended by the respondent in her appeal? That's the first issue. The second issue is, did the Court of Appeal err when it affirmed the decision of the trial High Court in awarding an amount of 500,000 Ghana cedis to the respondent by way of alimony or compensation after the dissolution of the marriage as contended by the petitioner in his cross appeal? So those were the 2 issues to be determined by the Supreme Court. Now let's get to know how exactly the Supreme Court discussed these 2 issues. Now when we say the Supreme Court in this case, we're referring to the majority of 3 males who have rendered the majority decision. The judgment of the Supreme Court will be taken to be the views expressed by those 3 judges. So at the Supreme Court, the respondent made a very interesting argument. Now, interestingly, the respondent's lawyer is also a woman, and the petitioner's lawyer is also a man. So it was more like men supporting men and women supporting women. So the argument that was made by the respondent before the Supreme Court was very simple. It says that the only argument made by the respondent is that since the 4 units of flats were constructed during the subsistence of the marriage between the parties, the respondent as a wife was entitled to a share under the well-known authorities of these courts in the cases like Mensah versus Mensah. Then he went on to say that the authorities are legion that irrespective of how property was acquired during the substance of the marriage, a wife is automatically entitled to a share of such property by operation of law. She calls this a legal and constitutional right. Respondent quoted a statement made by this court in the Mensah case supra to support her position that the sharing of spousal property should no longer be dependent upon substantial contribution principle, and that the property acquired during the marriage is presumed to be joint property. So that was the argument the woman put across at the Supreme Court. And when I say the woman here, I'm referring to the respondent. Now, what is the Supreme Court's decision on this particular matter? The Supreme Court started by saying that each case is always very unique and they are mostly fact sensitive. In other words, you must look at each case and draw a conclusion based on its own peculiarities. That is the first statement the Supreme Court made to caution the parties that it's going to apply the principle we all know, but it will take this fact as unique. The Supreme Court took time to review the previous cases on this subject, the cases of Mensah and Mensah, Acta versus Acta, Finn and Finn. The court reviewed all those cases, and just like the way the Court of Appeal also reviewed them, the Supreme Court did the same thing. Now, some of the conclusions they draw, I would like to read them directly for you from the case so that you could appreciate it. So, for example, the Supreme Court says that the combined effects of the decisions referred to supra is that any property that is acquired during the subsistence of a marriage, be it customary or under English or Mohammedan ordinance, is presumed to have been jointly acquired by the couple, and upon divorce should be shared between them on the equality is equity principle. The Supreme Court went on to say that this presumption can be rebutted by evidence. What this means in effect is that it is not every property acquired single-handedly by any of the spouses during the substance of a marriage that can be termed as a jointly acquired property to be distributed at all costs on this equality is equity principle. Rather, it is property that has been shown from the evidence adduced during the trial to have been jointly acquired, irrespective of whether or not there was direct pecuniary or substantial contribution from both spouses in the acquisition. He went on to say that with a decision in the Mensah, Kwasin, and Atta cases supra, it was no longer essential for a spouse to prove a direct pecuniary or substantial contribution in any form to the acquisition of the marital property to qualify for a share. It was sufficient if the property was acquired during the subsistence of the marriage. However, where such evidence exists, it is necessary that a spouse alleging such a contribution must render or offer it to qualify his or her share or portion in the property so acquired on the equity principle. The rationale behind this position was that the duties performed by the wife in the home, like cooking for the family, cleaning and nurturing the children of the marriage, which go a long way to create an enabling atmosphere for the other spouse to work in peace towards the acquisition of the properties concerned, was enough contribution that should merit the wife a share in the said properties. So the Supreme Court has been saying a lot of things, right? Says that yes, from the cases reviewed, it is true that all properties acquired during the time the marriage is subsisting are presumed to be jointly acquired, but that presumption can be rebutted when there is evidence to show that it was not jointly acquired by the parties, and as such should not be shared equitably between them. If there is such an evidence, a party who is alleging that it is not a joint property must produce evidence to prove that it was not a joint property. If there is no such evidence, the presumption will be taken to be true and the court will share it among them equitably. The court also clarifies that if a party is alleging that he is entitled to a particular share of the property because he contributed to its acquisition, that party has an obligation to produce evidence to show the contribution he's made. And the contribution has been settled that need not be financial alone. It can be non-pecuniary contributions or non-financial contributions. And the law has been settled that contributions made by a wife or the woman in the marriage, which are not financial in nature, they could be in the nature of taking care of the children or the family and nurturing them and taking good care of the home to afford the man some level of enabling environment or peace or good atmosphere, or to give the man that opportunity to be free and focus on working at some other places or engage in an economic activity to make money. All those contributions, which are in kind and not in cash, are good contributions that could entitle a woman to a share of property jointly acquired during the marriage. But I ask the question, is it every wife in a marriage who really performs their wifely duties very well enough to consider those wifely duties, contributions in kind towards the acquisition of property that is acquired during the marriage? And I think the Supreme Court answered this question. Let me read for you how the Supreme Court answered it. It must be emphasized, however, that it is not every wife to a marriage who diligently performs this marital role that the courts, since the days of Rima and Rima, Denny Adjei, that is Lord Denny Adjei, Lord Justice, have talked so much about. It is therefore necessary that such a contribution or non-contribution must be demonstrated in the evidence adduced at the trial. Again, in the Atta case supra, this court affirmed the position that properties acquired by gift or through succession cannot be described as jointly acquired marital properties. If a spouse acquires properties by gift from a donor or through succession, either intestate or testate, the other spouse who was not a beneficiary in any way under any of the circumstances cannot be described as a joint or part owner just because the donation, the bequest, or the device was made during the subsistence of the marriage between the donee or the successor and his or her partner. Now, the court is saying that if it is shown that a wife is not performing her wifely duties, she cannot use those contributions, wifely duty contributions, as a contribution in kind towards the acquisition of a property. In the same way, all of these issues about properties acquired during the marriage are presumed to be jointly acquired and all of that. If a party can show that that property was by a gift from someone to the party, or was by inheritance from the father or relative or from someone's estate, then it remains their personal property. It cannot fall within the category of properties that are jointly acquired. Then there was a very important reasoning by the Court of Appeal that the Supreme Court accepted or affirmed as correct. In fact, let me read for you what exactly the Court of Appeal said that was affirmed by the Supreme Court as the correct position of the law. Listen to it. It says that where a party or spouse takes an individual loan to develop his self-acquired plot during the subsistence of a marriage, the property so acquired shall not be considered a family property jointly acquired until the loan has been fully paid whilst the marriage subsists. In other words, if one of the parties in a marriage has earlier acquired his own plot of land, and during the subsistence of the marriage, the party goes in for a loan to develop that land, maybe say build a house on it, the law is that until the loan is repaid during the subsistence of the marriage, the property will not be considered to be a matrimonial property that will be jointly owned or distributed between the parties. In other words, I believe you're enjoying this video so far. You want to do us a favor as you watch and enjoy our videos. You want to like the video just now, do click on the like button to like it, and when you are done also please subscribe to the channel and drop a comment as well as know what you think. Do you agree with the Court of Appeal, the High Court, or the Supreme Court? What are your reasons for disagreeing with the Supreme Court or for agreeing with the Court of Appeal or the High Court? Let's know what you think in the comment section. Please don't forget also to share this video to a friend. If you have a land now and you are not yet married, but you later get married and during the course of the marriage, you went in for a loan in your own name and used the loan to build a house on that land, and you are still repaying the loan, if you are not done repaying the loan and the marriage is dissolved, that house cannot be shared among the parties as a jointly acquired property. But if you are done paying the loan before the marriage is dissolved, the property will be presumed to be jointly acquired, because the other side would argue that we gave you some contribution in kind to give you the enabling environment to be able to work and repay the loan. And that contribution we gave you, that enable you to go in, work hard and repay the loan, is our contribution in kind. Therefore, now that the loan has been repaid, the house belongs to the family. And if the marriage is no more, it must be shared equitably between the parties. So based on this analysis, the Supreme Court came to the conclusion that the Court of Appeal was right in setting aside the decision of the High Court. That is, the decision that the woman should be given a house was wrong. So the Supreme Court says that Court of Appeal, you are right in setting aside the decision made by the High Court to tell the woman to keep the house or to take one of the flats from the man. You are right, so we agree with you. So that was the conclusion the Supreme Court reached on the issue as to whether or not the woman was entitled to one of the 4 flats that the man has at cantonment. So on the last issue as to whether or not the woman was entitled to the 500,000 and the 1,500 cedis that was ordered to be paid her, the High Court said that yes, she was entitled to the 500,000, and the Court of Appeal also affirmed that decision. The Court of Appeal agreed with the High Court on that. The Supreme Court was saying that where 2 lower courts, that is the Court of Appeal and the High Court, has already affirmed the fact or found the fact to be true, if you want us to reverse it, you have to show that there is an exceptional circumstance that warrant the reversing of that decision. So the decision made by the 2 lower courts affirming that the woman was entitled to receive the 500,000 and 1,500 cedis from the man as a monthly maintenance fee was affirmed by the Supreme Court also. And that was the conclusion also reached by the Supreme Court on that second issue. That was a decision reached by the Supreme Court in this case. In a separate video, we'll talk about the dissenting view in the case of Peter Adjei versus Margaret Adjei. You don't want to miss that video as well. And please, if you want to watch any of our videos on ordinance marriages in Ghana, click the link here. I'm Godwin Selassie Dakpo, and this is Make It Legal.
Make it legal.